Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Phoenix, Arizona on January 11th through the 12th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode I'm pleased to be joined by Leslie Caldwell. Ms. Caldwell is currently a partner in the San Francisco office of Latham Watkins, and prior to this, she served as Assistant Attorney General in the DOJ's Criminal Division. Thanks for joining me today, Ms. Caldwell.
Thank you, Professor. Thank you for having me.
Now, last week, of course, the DOJ released a new FCPA Corporate Enforcement Policy. What are your thoughts about this new policy?
I think that this policy brings very significant changes for corporations in the FCPA space. I would go so far as to call it FCPA 2.0 from a corporation's perspective. It's really providing a lot more clarity and more concrete benefits to corporations who have FCPA issues. One of the most challenging things for a corporation that has an FCPA issue is deciding not what to do about it internally, because most corporations will investigate it and remediate it, but what to do when it comes to whether to report to the DOJ. This new policy really gives corporations something much more concrete than they've ever had before to guide them in making that decision.
Now, the policy is, of course, very similar, both procedurally and substantively, you could say, as well as in terms of its goals, to the DOJ's previously articulated FCPA Pilot Program, which was announced in April 2016, that you were involved in implementing and promoting while at the DOJ. What do you see as perhaps some of the major differences in the new enforcement policy, and were some of these differences perhaps considered but rejected back in April of 2016?
So I think the biggest differences are this new policy, this new enforcement policy provides much clearer and more concrete benefits for corporations that choose to self-report, cooperate, remediate, and that have good compliance programs. The pilot program provided benefits, but they weren't as clear or as definite. For example, under the new policy, there's a presumption that a company that voluntarily self-discloses in a timely manner, fully cooperates with the government, remediates the issues, and has a robust compliance program, all of which are fleshed out in more detail in the policy. There's a presumption that that company will receive a declination of criminal prosecution, absent some aggravating factors, which are also described in the new policy. That's a very big change from the pilot program. The pilot program said that prosecutors would consider a declination. Here you're telling companies, you will be presumptively entitled to a declination of prosecution, meaning you will not be prosecuted. There won't be a non-prosecution agreement. There won't be a deferred prosecution agreement. There won't be a guilty plea. The prosecution will be declined. That is a huge change.
Now, in terms of this presumption and the word declination, you've used that word a couple of times. It still is the case that even if a business organization does all that the DOJ wants it to under this enforcement program, there still is a requirement that the company disgorge and or forfeit any improper profits from the wrongdoing. Can that truly be called a declination, or is that just not an FCPA enforcement action, albeit under a different name?
I would consider that to be a declination because the criminal prosecution, the fact that the company is not being criminally prosecuted is a very, very substantial benefit. The company shouldn't be allowed to keep that which it got through bribery or corruption. So I think that that's not a prosecution. There's a very big difference between a prosecution where somebody has to plead guilty or be under the aegis of a monitor for an extended period of time, and a situation where a company simply has to disgorge profits that it should never have gotten in the first place.
Yeah, no, I agree with that, but on the same token, a non-prosecution agreement never resulted in criminal charges, nor did a deferred prosecution result in any actually prosecuted charges. So,
well, under both of those resolutions, Professor, as you know, the government would routinely file a public document that would go into great detail about the underlying criminal conduct, even if the company was not required to admit the conduct. And as you know, in the case of a deferred prosecution, charges were filed or are filed in court. A non-prosecution, they're not filed in court, but the conduct is described publicly. In the situation of a declination, generally the conduct historically has not been described in declination documents. Now, the DOJ has said that they plan to post the declinations on their website, so they will become public. There are companies that don't want anyone to know even about the fact of an investigation, including a declination, even if no prosecution was actually brought. So it's not a completely painless experience, but it's much more beneficial to companies than the alternatives that are available if they don't self-disclose or if they have aggregating factors as described in the DOJ's policy.
Were some of these new features that you just mentioned relevant to the new policy? Were they considered in connection with the 2006 pilot program? And if so, why were they rejected?
So we considered a whole range of options in considering the pilot program. One of the reasons why we called it a pilot program is because we really weren't sure what effect it was going to have. It turns out it was pretty effective, and the number of voluntary disclosures did spike significantly. We did consider having the debate really was between should we have a carrot or should we have a stick, and how big should the stick be and how big should the carrot be. I think this puts out a bigger carrot than was in the pilot program because it's more definitive and it's more clear, so that companies can see that they are essentially entitled to a declination if they adhere to all of the things that are laid out in the policy. Of course, assuming that there are no aggravating circumstances like very pervasive behavior or involvement of executive management or the boardroom. But this is something that provides a much bigger carrot. I think the pilot program was always intended to be temporary. It was always intended to be an experiment and to be tweaked when it expired, which is now what has happened.
Would you agree that the DOJ seems to be increasingly over the years moving towards a de facto FCPA compliance defense? And the reason I say de facto FCPA compliance defense is, of course, it takes an act of Congress to actually change the statutory terms of the FCPA. But do you agree that the DOJ is increasingly moving towards a de facto compliance defense?
No, I don't agree with that. And in fact, one of the things we considered in discussing the pilot program was whether we should have a compliance defense, and we rejected that idea. And I think we did. I think that was the right thing to do. And most modern companies all over the world, but particularly in the United States, U.S. issuers and those who would most likely be subject to the FCPA, have very robust compliance programs. The issue is not really whether the compliance program is good, whether it looks good, whether it feels good. The issue is whether the compliance program is operationally effective. So you have to see what resources are given to the compliance program. You have to see what the culture of compliance is at a company. You have to make sure that the compliance function at a company is empowered, that it has access to upper management and the board. That's very hard to put into a piece of paper, and as the government, you can't just say that no matter what you do, if you have a good compliance program, you'll get a pass, because these situations are all very fact-specific. And one reason why we made the pilot program exactly that, a pilot program, was because we wanted to see whether there could be some kind of overall guidance that could aid companies, each of whom finds themselves in completely different factual circumstances. So I think the compliance defense is not helpful. This new policy, like the pilot program and like prior enforcement policy, puts a lot of weight on the value of a compliance program and the effectiveness of a compliance program and the empowerment of a compliance program, as it should. But I don't think that it would be fair to have a compliance defense.
Both the new DOJ policy as well as the prior pilot program have as a main goal of increasing the prosecution of individuals who violate the FCPA. Now, since the 2016 pilot program, the DOJ has self-identified 7 corporate matters as being resolved consistent with the pilot program, and each one of these is on the DOJ's website. But yet not one of those matters resolved consistent with the pilot program has involved a related prosecution of a company employee. And if that was the goal of the pilot program, is that a measure that the pilot program was unsuccessful in achieving one of its main objectives?
So first, I don't know which cases you're speaking about, but it's always hard to say whether there are individuals that have been prosecuted just because a corporation has resolved its matter. It's very common for a corporate resolution to occur well in advance of charges being brought against individuals, and that's particularly true in the FCPA space, where many of the individuals who are involved in FCPA violations are located overseas. There may well be sealed indictments in those cases against individuals. I'm not saying there are, I just don't know that there aren't. There may well be ongoing investigations. That would all be very common in the FCPA space. The goal of the pilot program really was part of the goal was to increase the prosecution of individuals, but the way to do that, and what the pilot program was really designed to do, is to gain access to information that is in the possession of companies. Companies, when they find a violation of the FCPA, they generally conduct an internal investigation. They gather facts, they gather information, they understand and know who are the individuals who are responsible. So by rewarding self-reporting, what we were really trying to do was to get companies that otherwise might not self-report to come in and provide us with that information. And then we could work to build those cases, if they were buildable, against individuals. So that was the goal, and I think that what we've been seeing, what the department has been doing, and what we've been seeing from outside watching the department is that that's exactly what they're doing. These cases take time, though, and I think there's always a rush to comment on FCPA statistics, but I think that's not really a good way to measure FCPA success.
Well, I completely agree with that latter point, that there's often a rush to comment on FCPA statistics. Just for listeners' benefit, there are 7 corporate matters on the DOJ's FCPA website that are under the pilot program and now the corporate enforcement program subpage. And point taken that sometimes individual cases are filed under seal. Sometimes individual enforcement actions lag a corporate enforcement action, but at the time, those 7 matters have not involved any related prosecution of a company employee. And I'd like to broaden the discussion out a little bit more now. We find ourselves just a few weeks shy of the FCPA's 40th anniversary. And a question I've been asking many guests on the podcast over the last several months is, as the FCPA turns 40, do you believe the FCPA has been successful in achieving its objectives, which, of course, the meaning of success, I guess, can take many different forms. But how would you answer that question?
So I think I'll start with a point that I always make, which is that criminal prosecution is never the solution to a broader societal problem. It can only do so much. I do think that the FCPA, particularly in the last 15 years or so, has been very effective. It's raised an awareness of the importance of anti-corruption efforts worldwide. Other countries that previously did not do anything involving corruption in their own countries are now very actively investigating, and I'm talking about countries all over the world, countries in Asia, countries in Africa, countries in South America, countries in Europe. They are all doing, not every country obviously, but many countries are now very actively pursuing anti-corruption matters in their own jurisdictions, and I think that's because of the FCPA. I think that the FCPA has also raised a real awareness in U.S. corporations and those who trade on U.S. exchanges of the importance of following the law, not just the FCPA, but the importance of compliance generally. I've seen through my own eyes in the last 15 years or so dramatic increases in the number of resources that are devoted by major corporations to compliance, and I'm not just talking about the FCPA. I think that's a good thing. I think it makes corporate America and the corporate world a better place, a more ethical place, a more fair place. And I think that that's been extremely effective. And I think a lot of that has to do with the increased emphasis, which really started in the early 2000s, on FCPA prosecution.
What would you say to the point, though, that if a law was being successful, and again, I know there's many different definitions of success, as you just sort of alluded to, one being soft enforcement, i.e. how are business organizations reacting to a new era of enforcement, and that's very important. But if a law is being successful, would we not expect to see less, not more, enforcement of the law as that law matures? Because in the FCPA context, we've seen really the opposite. And of course, 2016 was a record-breaking year in terms of FCPA enforcement activity. Is that a measure of success or perhaps something different?
So I think it is a measure of success. I think first, the FCPA, as you said, it's almost 40 years old. For about the first 25 of those years, enforcement of the FCPA was quite scant. There certainly were enforcement actions, but it wasn't a priority of the department. It wasn't a priority of the FBI. Only really in the early to mid 2000s did it become a larger priority, and did the DOJ start focusing on it in a more systematic, organized way. And while I was Assistant Attorney General, we created 3 FBI squads to focus on not just FCPA, but anti-corruption generally, including kleptocracy, where leaders of countries steal money from their own countries or take bribes and use that money to buy various luxury things here in the United States. So I think that corruption is rampant all over the world, as is fraud, as are crimes of violence, as are narcotics trafficking. Just because they continue doesn't mean the laws outlawing them and enforcing them are failing. And to the contrary, I think in the case of the FCPA, the number of cases that are being brought because of the organized focus and the systematic focus that not only DOJ, but now the SEC and law enforcement all over the world are bringing, I think that's the reason why the number of cases has gone up. It's not because there's more corruption, it's just because there's a stronger, more coordinated, more energetic effort to pursue the corruption.
Now, granted, with the recent development of the DOJ's corporate enforcement policy, that is a tweak to DOJ policy, but as the FCPA turns 40 and as we look forward here, do you have any other suggestions for how the FCPA, either the statute itself or DOJ and SEC enforcement policy, could perhaps be improved even better to accomplish the FCPA's laudable objective of reducing bribery and corruption in the global marketplace?
Well, I think that 2 things that I think were very important have already happened, and hopefully they'll continue. One is the uptick in international cooperation and coordination and information sharing. And I'm not talking just about situations where the United States learns of a crime and tells another country. I'm talking about situations where, for example, the United States and another country work together from the outset, investigating an FCPA violation, and coordinate. I think the more information that gets shared internationally, country to country, law enforcement to law enforcement, the better. I think it benefits countries all over the world. Corruption isn't good for anyone. It's not good for any country. Some countries have more severe problems than others, but I think it's good to work together to try to thwart corruption however we can. And the second change, and I think this has already happened, is I think DOJ and both the SEC and the DOJ should focus their resources on the bigger cases, and that's really what they've been doing in the last few years. And they should focus their resources not on the one-off small case or not on the case involving excessive gifts and gratuities, but on the case where there really is pervasive corruption or significant corruption. I think most of the cases that have been brought in the last 5 to 6 years fit that description, and I think that should continue, and I hope it does.
Today's guest has been Leslie Caldwell. She is currently a partner in the San Francisco office of Latham Watkins, and prior, she served as Assistant Attorney General in the DOJ's Criminal Division. Thank you very much for sharing your insight and perspective with the FCPA Flash podcast.
Thank you, Professor. It was my pleasure.